I invite the next participating delegation, Bangladesh, to address the court. Let me call upon His Excellency, Mr. Riaz Hamidullah, to take the floor.
Mr. President, members of the court, it's my distinct honor and privilege to address the principal judicial organ of the United Nations on behalf of the People's Republic of Bangladesh and participate in these advisory proceedings on the legal consequences arising from the policies and practice of Israel in the occupied Palestinian territory, including East Jerusalem. Bangladesh fought for 23 long years to gain her independence and finally achieved it through a bloody war in 1971, during which 3 million people had to sacrifice their lives. In the early days of independent Bangladesh, in 1972, our father of the nation, Bangabandhu Sheikh Mujibur Rahman, said, I quote, "The world is divided in two parts, oppressors and oppressed, and I am with the oppressed," unquote. As Bangladesh pursued her own self-determination, our constitution mandated us to support oppressed peoples worldwide who are fighting imperialism, colonialism, or racism. This duty is outlined in Article 25C of our constitution. In accordance with this duty, Bangladesh is participating in these advisory proceedings to contribute to the realization of the right of the Palestinian people to self-determination. We aim to achieve this by providing this court with our perspectives on the questions asked by the UN General Assembly in the current request for an advisory opinion. Bangladesh has long reiterated the call to end Israel's occupation of Palestine and to achieve a lasting and permanent solution which entails the establishment of a sovereign and independent Palestinian state along the pre-1967 borders, with East Jerusalem as its capital. We firmly believe that the court must heed the long overdue call to holistically examine Israel's occupation and render an opinion on the legal status of the occupation as a whole. As we heard in this very hall just last month, Gaza has been described as a living hell. On 20th May 2021, even before the ongoing war, Mr. Antonio Guterres, the UN Secretary General, said, I quote, "If there is a hell on earth, it is the lives of children in Gaza," unquote. I stand before the court also in the context of the fast developing circumstances in Rafah, with grave humanitarian implications for the 1.4 million Palestinian people, nearly half of them children. The ongoing war represents one of the most shameful catastrophes in the history of the modern era. The UN agencies and other humanitarian aid organizations on the ground have warned of a humanitarian disaster engulfing the tiny enclave of 2.3 million people with shortages of food, fuel, drinking water, and medicines worsening by the day. The killing of thousands of innocent civilians, particularly children, the destruction of their homes, the occupation of their ancestral lands, and the deliberate obstruction of their access to food and water all constitute blatant violations of international law and serve as textbook examples of ethnic cleansing. Bangladesh firmly believes that an advisory opinion on the questions posed by the General Assembly would undoubtedly represent a critical and logical step towards ending the illegal occupation. The dismantling of this occupation would, in turn, address the root cause of Israel's violent subjugation of the Palestinian people. We elaborated on these matters and the underlying reasoning in our submissions before the court, Mr. President, on 24th July and 25th October last year. It is pertinent to recall that just 4 months back, the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territories, Francesca Albanese, in her report, brought up several appalling facts. I would consider it apt to quote one pertinent aspect, and I would quote, "In the occupied Palestinian territory, the fundamental right to life is under threat, as indicated by the mortality rates of Palestinian children. The neonatal mortality and infant mortality rates in the occupied Palestinian territory are respective 9.3 and 12.7 per 1,000 live births, rising to 14.8 per 1,000 live births for children under 5, while in Israel they are 1.7, 2.7, and 3.4 per 1,000 live births. In addition to direct attacks on the right to life, Palestinians also endure structural violence and racial discrimination, which impedes their full development." Unquote. These structural violence of the occupation and the deliberate and excessive use of force against the Palestinians are indeed not limited to the recent events in Gaza. As the special rapporteur, Ms. Albanese, stated in her 2023 report, I quote, "The specter of death looms as a dominant element in the lives of Palestinian children. This reality exerts a psychosocial toll on those who manage to survive, as pointedly expressed by Oadia, a 14-year-old girl. I quote, as she said, "Fearing death does not prevent you from dying, but it prevents you from living." Unquote. Thousands of Oadias keep crying in silence, deprived and disenfranchised for decades. Ending the occupation would necessarily bring an end to the violence that is exercised upon Palestinians on a daily basis. However, there is no end to the occupation in sight, nor is it likely to end through political means alone. It has become interminable. That much was all but confirmed by Israel's Prime Minister, Mr. Benjamin Netanyahu, on 18 January 2024. The court's intervention to us is therefore both timely and necessary. As I proceed with this oral statement, I wish to address whether the occupation of Palestinian territory by Israel is illegal or not. Even though the great majority of states participating in these proceedings, including Bangladesh, are firmly convinced that the occupation is illegal, we note that 2 states contend that it is not. Next, I'll state the legal consequences that, in our view, derive from the illegal status of the occupation. On Israel's illegal occupation, Mr. President, members of the court, the fundamental question posed by the UN General Assembly regarding the legality of the Israeli occupation is grounded in established international norms and legal principles. The State of Palestine, in its written statement, underscores the colonial and acquisitive nature of the occupation, emphasizing its deleterious impact on the Palestinian people. The occupation, characterized by persecution, racial discrimination, and apartheid, stands in clear violation of 3 preemptory norms of international law: the right to self-determination, the prohibition of acquiring territory by force, and the prohibition of racial discrimination and apartheid. Numerous submissions have echoed these sentiments, highlighting the temporary nature of belligerent occupation as mandated by international law. The annexation of occupied territory and the settlement of the occupying power's nationals in the occupied area are explicitly prohibited, constituting illegal acquisition of territory under the UN Charter and relevant UN resolutions. Israel's prolonged occupation, coupled with its policies of colonization and annexation, underscores its illegality under international law. These actions not only contravene the UN Charter, but also violate general international law, including the preemptory norm prohibiting the acquisition of territory by force. Furthermore, arguments put forth by states and international organizations reject any justification for Israel's occupation on grounds of self-defense. The occupation violates fundamental principles of international law, including the right to self-determination and the prohibition of acquiring territory by force. The advisory opinion on Wall, which concluded that Israel cannot rely on self-defense to justify its actions, reinforces the notion that the occupation cannot be justified under international law. While the countries supporting Israel in these advisory proceedings have primarily focused on jurisdictional questions, a few states have addressed the merits of the occupation. One contends that an occupation can never be unlawful regardless of violations of international humanitarian law. However, this argument stands in contravention of established legal principles and has been widely found to be incorrect. Switzerland's distinction between the law of occupation and the legality of occupation further elucidates the legal framework surrounding the issue. An occupation that involves annexation or de facto control of the occupied territory constitutes an illegal acquisition of territory by force as prohibited under international law. Ultimately, Israel's occupation, characterized by its acquisitive, colonial, and annexationist nature, represents a clear violation of international law. It serves as a means for the illegal acquisition of territory and must be brought to an immediate and unconditional end. I may also recall the UN Security Council Resolution 2334 of 23 December 2016, which reaffirmed the obligations of Israel, the occupying power, to abide scrupulously by its legal obligations and responsibilities under the 4th Geneva Convention in regard to the protection of civilian persons in time of war. That Security Council resolution also condemned all measures aimed at altering the demographic composition, character, and status of the Palestinian territory occupied since 1967, including East Jerusalem, including, inter alia, the construction and expansion of settlements, transfer of Israeli settlers, confiscation of land, demolition of homes, and displacement of Palestinian civilians in violation of international humanitarian law and relevant resolutions. Israel has flagrantly violated this and all other Security Council resolutions, and it continues to do so in furtherance of permanently maintaining its illegal occupation of Palestinian territory. At a more granular level, may I refer to the approaches of assessing legality advanced by the former UN Special Rapporteur, Michael Link, in his 2017 report to the UN General Assembly, and the current Special Rapporteur, Francisca Albanese, in her 2022 report. These are apposite and relevant to the Court's task in this case. The two approaches overlap and interrelate, but ultimately provide two pathways for determining the legal status of the occupation. I may humbly request the Court to consider the Link report, where he proposed a 4-part test for determining the legality or illegality of an occupation. The Special Rapporteur's approach also fits within the parameters of the Court's advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia. That opinion arose out of Security Council resolution declaring South Africa's continued presence in Namibia illegal. If South Africa's mandate could be found to be illegal due to its violation of the applicable international legal principles, so too can Israel's occupation by reason of its violation of the same principles. Therefore, applying one or both of these frameworks, which Bangladesh endorsed for the reasons stated in our written submissions, we respectfully submit that Israel's occupation is undoubtedly illegal. I would now turn on the legal consequences. Mr. President and members of the Court, there is a broad consensus that Israel, through its denial of the Palestinian people's right to self-determination, has violated preemptory norms of international law. These violations include persecution, racial discrimination, and apartheid against Palestinians, as well as the occupation, colonization, and annexation of Palestinian land. These systematic breaches severely undermine the rights of Palestinians as a people and Palestine as a state, while also hindering the prospects for a just and lasting peace in accordance with international law and relevant UN resolutions. Consequently, international law mandates the complete, unconditional, and immediate cessation of these internationally wrongful acts. All states and international organizations that have condemned Israel's conduct agree that these systematic and grave breaches carry legal consequences for Israel as the responsible state, other states, and the United Nations and other intergovernmental organizations. So, on legal consequences for Israel, first, Israel must cease all acts preventing the exercise of the right to self-determination by the Palestinian people, including rescinding discriminatory laws and measures. This cessation includes withdrawing occupation forces, dismantling illegal structures such as settlements and the wall, and repealing annexation-related legislation. And secondly, Israel must provide reparations for the damages caused and guarantee non-repetition. On the legal consequences of all other states, first, all states must ensure the immediate cessation of any impediment to the exercise of the Palestinian people's right to self-determination and uphold the prohibition of acquiring territory by force and racial discrimination and apartheid. And secondly, states must not recognize the illegal situation resulting from Israel's wrongful acts, including in Jerusalem, and must not provide aid or assistance to maintain this situation. Cooperation is essential to ensure Israel's compliance with international law and humanitarian standards. On legal consequences for the United Nations, first, the UN General Assembly and the Security Council should consider further action to immediately end the Israeli occupation and remove obstacles to Palestinians' rights, including self-determination. And secondly, immediate action is necessary to end the system of apartheid set up by Israel, with relevant UN resolutions implemented without delay. Mr. President, distinguished members of the Court, the promise of a Palestinian state based on a diplomatic settlement grounded in law has been a prominent feature of the international agenda since 1948. 75 years later, there exists a vast body of state practice and opinion jurists that emphatically support the Palestinian people's right to an independent state. The UN Security Council and the General Assembly have adopted numerous resolutions since 1948 on the question of Palestine, recognizing, among other rights, the right of return for Palestinian refugees and the right of Palestinians to establish an independent state along the pre-1967 borders. Additionally, both the UN General Assembly and the Human Rights Council have acknowledged the Palestinian people's right to self-determination. Importantly, in 2004, this court, in its advisory opinion on the wall, explicitly affirmed the Palestinian people's right to self-determination under international law. Bangladesh, drawing on our agonizing struggle for independence, recognizes how the state of Palestine consistently and conclusively reaffirmed her commitment to a peaceful solution. This solution, in accordance with international law and based on the aforementioned terms of reference, aims to ensure the fulfillment of the Palestinian people's inalienable rights under international law. These rights include self-determination, the right of return, the realization of independence and sovereignty of the state along pre-1967 borders, with East Jerusalem as its capital, and the aspiration to live side by side in peace and security with Israel. The Court's steadfast commitment to universally uphold rule of law, coupled with its principled stance on the legality of Israel's half-century temporary occupation of the occupied Palestinian territory, would shine a light of hope on the beleaguered Palestinian people. A decisive determination by the Court of the illegal status of the Israeli occupation of Palestinian territory and the legal consequences that arise from such status, including an immediate, unconditional, and complete end to the occupation, would help secure the identity, respect, dignity, and existence for the present and future generations of the Palestinian people in a state of their own at peace with Israel. Mr. President, members of the court, Palestinians are no expendable people. As much as this advisory opinion involves legal questions, it poses an exceptional moral issues for the humanity. I stand before the court as Bangladesh deem it our sacred duty to uphold international law as well. On behalf of Bangladesh, I would therefore respectfully request the court to give full consideration to the importance of an advisory opinion at this critical moment. I'd like to thank you, Mr. President, as well as the distinguished members of the court for granting Bangladesh this opportunity to participate. Thank you.
I thank the delegation of Bangladesh for its presentation